On Thursday, the Supreme Court delivered split opinions concerning Donald Trump's financial records. While they ruled the Manhattan District Attorney has a right to the records, they also ruled that House Democrats do not have a right to them. The Manhattan case came down to a 7-2 ruling. Chief Justice John Roberts joined the majority of Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, Elena Kagan, Brett Kavanaugh, and Neil Gorsuch. Dissenting were Justices Clarence Thomas and Samuel Alito. This opinion, as well as their other, is subject to review by lower courts. Trump's claims that he is immune from state criminal subpoenas in the New York case were rejected. Yet, in the congressional case, the justices rejected earlier rulings that favored House Democrats. The High Court also ordered the lower courts to consider the separation of powers more carefully. Because of the split opinion, Trump's financial records and tax information are unlikely to be released to the public before the presidential election in November. The House Oversight Committee sought the records in the investigations of Trump's former personal attorney, Michael Cohen, who claimed the president both inflated and deflated his assets, whichever was favorable to him at the moment. Additionally, the same panel is investigating the president's failure to disclose the hush money payment going out to adult film actress Stormy Daniels on his 2017 disclosure form. The Office of Government Ethics had said Trump should have listed the payment, which was owed to Cohen, who covered it for him, as a liability. The separate subpoenas were issued by the Financial Services and Intelligence Committees to Deutsche Bank, requesting information on Trump and the members of his family, including his oldest 3 children. The Financial Services Committee issued a subpoena asking Capital One for information on 15 of Trump's businesses. The panel is investigating potential foreign money laundering. House Intelligence Chair Adam Schiff, DCA, said his committee's probe sought to uncover whether any foreign actor was sought to compromise or holds leverage, financial or otherwise, over Donald Trump, his family, his business, or his associates. The Supreme Court's split opinions are the first time it has ruled on a matter that involved the president's business. Trump, while in 2016 agreeing to release his tax returns after an audit, never did, breaking with a long-standing tradition of candidates releasing their records. In our judicial system, the public has a right to every man's evidence. Since the earliest days of the Republic, every man has included the President of the United States, wrote Roberts in the case brought by Manhattan District Attorney Cyrus Vance. Vance's office is investigating the hush money payments to Daniels and Karen McDougal, another woman Trump allegedly had an affair with before the 2016 election. Both women claimed to have been paid to keep quiet about the affairs before the election. Vance has not given any indication of an investigation or whether there are potential charges in the case. In a lower court hearing in New York, an attorney for Trump said he would theoretically be immune from an investigation, even if he shot someone on Fifth Avenue. This was after Trump claimed during the 2016 campaign that he could stand in the middle of Fifth Avenue and shoot somebody, and I wouldn't lose any voters. Vance said in a statement that the Supreme Court's decision is a tremendous victory for our nation's system of justice and its founding principle that no one, not even a president, is above the law. Our investigation, which was delayed for almost a year by this lawsuit, will resume, guided as always by the grand jury's solemn obligation to follow the law and the facts, wherever they may lead, continued the statement.